This morning on the Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Good to be with you again.
I'm curious, how much rain did you get in the farm there in Jackson County?
I think it's, I'm real close to the edge of Jackson County, kind of really at the last tier of northern tier of Shawnee County, but about, when you add it up over the days, I think about 2.5.
2.5. Needed, though, right?
Oh, yeah.
All right. Let's get to it. And today, a lot of the focus is going to be on several significant recent developments involving the Swampbuster program. And probably as long as you've been doing the program, Ag Issues program on 580, you have talked about the Swampbuster program. This goes clear back when it started, going clear back to the 1985 Farm Bill.
Yeah, I've been involved in Swampbuster more than I ever envisioned being involved in Swampbuster. I was involved in one of the most prominent cases ever involving Swampbuster, and that's the Barthel case out of Nebraska, when NRCS was messing around with a culvert in a South Fork of the Elkhorn River in Sand Hills, Nebraska, saying you couldn't change the scope of the drainage device. And we all felt, well, that's not what the statute says. You can do whatever you want with a drainage device as long as it doesn't change the flow and the drainage of the land. It's the land that should be the focus of Swampbuster. And the Eighth Circuit Court of Appeals agreed with that. But it still took the government a number of years to decide that they better comply with that. And, after a number of lawsuits during that case against the Secretary of Agriculture, and then even after the court's opinion came out, finally got things resolved. Unfortunately, both of the ranch couple died in the process because it took, from the state action all the way through the federal action, it took over 20 years in court. And that's one of the things with the Swampbuster program. And we'll talk about a couple of cases today, and you think of the length of time. People need to listen about the length of time that I talk about, that these farm families got tied up with the Swampbuster problems that they had on their farm. It takes an enormous amount of time, and you need to have real good legal representation from the start of the process, from the start of the administrative process all the way through, or you can really, really get abused.
Well, and first part of this, one of the things is talking about identifying a wetland, and that poses the question, well, what are some of the things that need to take place? But this is where it sounds like NRCS was pretty much nailed to the wall on how it was identifying wetlands.
Yeah, the wetlands have three characteristics. They have to show the government has to show there's presence of hydric soil. There has to be soil inundation for at least 7 days, or saturation for at least 14 days during the growing season, and then there has to be a prevalence of hydrophytic vegetation and wetland hydrology under undisturbed conditions. In other words, in order for a tract to be a wetland, it has to have hydric soils, hydrophytic vegetation, and wetland hydrology. You can't have just one of those. Again, I was involved in another case coming out of Iowa, the B&D Land and Livestock case, where the court said, no, NRCS, you have to show all three of those. All three of those have to be present. You just can't say that it's a wetland subject to Swampbuster based on the presence of one of those characteristics. Well, then there was a very significant case coming out of Indiana. This case was finally decided about 5 years ago, but it started back. The litigation in this one, Greg, involved a farm that this couple had owned since the early 1980s, and it had been continuously used for livestock and grain production for over 150 years. Then the tenants participated in federal farm programs. So the farm goes into farm programs. And again, that's another point I want to get across. Anytime you receive some type of taxpayer support, you're going to give up a level of freedom. And that's what's involved here in the Swampbuster program. You can participate in it if you want, but if you do so, then you're going to be subjecting yourself to the rules of those particular programs that you're participating in. You don't have to participate in them. And I may come back to that later if we have time with another case that's been filed out of Iowa recently challenging Swampbuster on constitutional grounds. But the economics may indicate that you have to participate. You just can't make it without the farm programs bolstering you economically. But back in 1991, or let me take it back even further than that. In 1987, this farm couple was notified that their farm might contain wetlands because of the presence of hydric soils. And I could take you all the way through this thing. I won't, in the interest of time. We don't have enough time to do that. But this started in 1987. When was the case finally decided? 2019. 32 years later, this thing got resolved favorably for the farmers. Now, in the meantime, the husband had died. But what happened was you had the government coming in saying, well, we think this is a wetland. You've got the presence of one or two, not necessarily three of these conditions that are required. And then they removed some trees, and over the process of time, the NRCS/USDA had amended had written some regulations saying that, well, the removal of woody vegetation is impermissible under the program. Well, that's not in the statute, and that came up in another case we'll get to in a bit. But this thing goes on and on. But ultimately, while they lost in the federal trial court, and you're in the federal system because this is a federal program that's involved, the Seventh Circuit Court of Appeals 5 summers ago, in the summer of 2019, said, look, you can't determine the presence of whether there is a wetland subject to Swampbuster just solely on a farm that is somewhere else, maybe in the drainage shed of this particular area where this farm is located at. No, you need to look at the characteristics on that farm. You didn't send a hydrologist to personally examine the property. You claimed instead that your comparison site that you used wasn't even necessary, and the court didn't buy that. And the government claimed that the removal of woody hydrophytic vegetation from hydric soils to permit the production of an ag commodity was all that was needed to declare the area a converted wetland, and therefore a violation of Swampbuster. And of course, if you're in violation of Swampbuster, not only are you going to lose your government benefits, but you can't farm your other land either. So that's a problem. Now, the appellate court looked at this, and they said, well, the government's understanding of the statute is way too narrow, and because hydrology was the basis for the change in the wetland determination that the government had made, the removal of trees, the court said, is just a factor to determine whether we have the presence of a wetland. But it's not the determining factor. It's just one of many factors, and the government was focusing on that exclusively. And the court said that's not permitted. That's not permissible under the statute. And the court pointed out that the NRCS never indicated that the removal of trees changed the hydrology of the property during the agency appeal process. And that's a point the government ignored throughout the process. And again, I come back to the point that gave us a victory in the Barthel case, is that the government was just looking at the drainage device and saying, well, you can't change the size or the scope of that drainage device. And the court said, no, that's not right. The impact has to be, what does that drainage device do to the land? And if it increases the drainage and brings more farmland into production, possible production, then there's a violation. But you can do whatever you want with the drainage device. The court said the same thing here. You can remove trees. That's not the point. The point is, what does that do to the property? And that's the court really scolded NRCS, and I'll quote the court here just so people can hear what the court said. And this is the judge speaking. It said, quote, rather than grappling with this evidence, the hearing officer used transparently circular logic, asserting that the agency experts had appropriately found hydric soils, hydrophytic vegetation, and wetland hydrology, end quote. And so the government pretty well got brutalized by the appellate court's decision for its lack of candor and its incompetence in that case. So that was an important case, but that was 5 years ago, and we've had more development since then, Greg.
And somewhat this decision, or that decision, in some aspects, or from the notes I see, led to abuse of the NAD process and delays that basically go back costing the farmers a lot of money in many cases.
Well, the decision you're referring to was a decision that the government made, USDA and NRCS, back in 1987, to change the rules to include farm wetland under the jurisdiction of Swampbuster. That's what I firmly believe has led to the abuse of the NAD process and delays that have cost farmers, I think, untold millions of dollars over the years. And the courts have had to sort all that out in some of these really prominent cases.
Yeah. 37 years ago in that aspect, too. Yeah. So, Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest as we're reviewing some of the recent cases, recent court developments concerning the Swampbuster rules. And, Roger, this next portion started back in 1990. This is better known as the Grassley Amendment by Iowa Senator Chuck Grassley, but it also involves a recent case as well in association with the Grassley Amendment.
Yeah, that's right. And this case is sitting at the U.S. Supreme Court right now on a cert petition, waiting for the court to rule on that. Now, keep in mind, there are two other cases that the Supreme Court, I think, is going to decide by the end of this term. So probably in June, we're going to get these decisions on agency deference. And I think they are sitting on the Swampbuster case that I'm going to talk about here in a second, depending on deciding whether they're going to take that case, depending on how the deference cases come out. And that's a big deal. And I thought back in January when this case, known as the Foster case, came up for discussion at a conference, we were going to get the cert decision then, and they passed on it. They didn't say no. They didn't say yes. They set it aside. I think then that signaled to me, okay, they're going to hold this until we get the opinions on agency deference. Then they will decide whether they take the Foster case. And if they change the deference rule, if they lower the deferential standard, if they give less deference to government agencies, then I think they're going to take this case. So what does this case involve? This is factually, it's from southeast South Dakota. Arlen Foster and his wife, Cindy, she's now deceased. They farmed in that area for many years. And interestingly enough, it was Arlen's predecessor and his family, his father and his grandfather, that back in 1936 planted a conservation tree belt to preserve the soil. And what has happened now is that, of course, in South Dakota, when you have snow, it melts, and the tree belt worked fine. It piled up the snow there, and then you get water from the snow melt. And the government came in and said, well, you've got an 0.8 of an acre portion of your field that is a wetland, and they certified it as a wetland in 2011 under the Swampbuster provisions. And at its deepest point, it's about 8.5 inches deep, this 0.8 of an acre spot in his field. Well, he requested a review of that certification, and in 2011, there was the recertification that was done, and the government said, well, yeah, that is a wetland. And he challenged that, and he said, no, I've got some changed conditions here, and I want a review of that certification. And what the Grassley Amendment did back in 1990, Greg, was say that a farmer has the absolute right and is the only person that can request a review of a certification from the government upon demand. There are no requirements in the statute that the farmer has to establish to get a review of a certification. It's when they request it, the government has to come out and certify it again. Well, the problem is the government wrote some regs. The USDA and NRCS wrote some regs and said, well, we'll only do that if the farmer shows that their circumstances has changed or that we made a mistake on the prior certification. That's not in the statute. And so the government declined to review this, saying, well, Arlen didn't show any changed conditions, although it would appear that he did based on the evidence. And he's lost in the trial court. He's lost in the Eighth Circuit Court of Appeals. And the courts have upheld the NRCS regulation that layered in those requirements that the statute doesn't have, and that Senator Grassley said clearly was not his intention when he wrote that and got that passed in the 1990 Farm Bill. That has been upheld by the courts under the high deferential standard that is given to government agencies. So if these two cases that are currently before the court lower that deferential standard, then I think they're going to take this case and we'll probably get a reversal of the Eighth Circuit opinion because the government will no longer give as much deference to administrative agencies. So that's a big case that is waiting for the Supreme Court to determine whether they're going to take it. But again, it's behind those two other cases involving government agency deference, which are absolutely huge, of major importance to us in agriculture as to what the court's going to do with those.
So much of this, too, is looking at, is a farmer forced to participate or not forced to participate in the farm program in order to be able to farm?
Well, economically, many farmers probably would say, yes, I have to. I can't do it without crop insurance. I can't do it without the government payments, whatever form I take them in. It just won't work for me. And so from an economic standpoint, the answer is probably yes. Now, from a legal standpoint, the answer is clearly no. You don't have to. You can farm and keep the government out of your business if you don't take any taxpayer subsidies or taxpayer dollars to assist your farming operation. And that's really what's at issue in this next case, which was filed just less than 2 weeks ago out of Iowa. And this is a front-on constitutional challenge to the Swampbuster program as a per se governmental taking. And actually, there are 5 claims, and a couple of the other claims say that it exceeds the power that the Congress has to regulate farms under the Commerce Clause. A fascinating case comes from eastern Iowa, just east of Cedar Rapids a bit, prime farm ground, and we'll see what happens with that one. I think the takings claim is questionable in that one again because government's not taking anything from you. It's just if you're going to participate in federal farm programs, then you have to put a conservation plan together. You have to be in compliance with Swampbuster and Sodbuster and all of that. And those are the requirements of the program. Now, the Commerce Clause claims, I think those have legs because when we're looking at, say, Arlen Foster's 0.8 of an acre in the middle of his field in southeast South Dakota, there is no connection with any type of interstate commerce at all. It's not connected to a stream that connects to a river that actually is a water of the United States. That is an isolated puddle at certain times of the year, and not even every year, that has no connection with interstate commerce. I think that argument in this Iowa case could have legs to it. The takings one, I think, is tough. Also, the unconstitutional conditions claim that they make, I think, would fail for the same reason, because you're not forced to be in the government programs. It's just, if you're going to do that, then like I said earlier, you're going to have to give up some freedoms, and those freedoms that you're going to give up are manifested in the fact that you have to comply with the government's requirements.
Oh, the fun of these cases. And as you had mentioned, you have been going at this for quite some time. You've been involved in some of the biggest cases. I would say, does anything surprise you? But I think I know the answer to that question.
Yeah, no, not really anymore. There were a lot of eye rolls, and I can't believe that the government was doing this years ago, but no, it doesn't really surprise me anymore. We just kind of look at it and see, well, how can we best represent these farmers against the government? But I come back to a point I made earlier. If we have a farmer that's listening, and you get crosswise with any administrative agency, whether it's USDA, NRCS, whatever, make sure you have legal representation from the get-go. And I know it's expensive, and Arlen Foster wouldn't have made it had he not had free legal help from a major group out in California that's helped him with this. And there are those groups that are out there that will help. We would have never won the CRP case years ago, Greg, on the self-employment tax issue, if it weren't for major contributions from not only farm groups, but environmental groups in that one. So those groups are out there, but you do need to have good legal representation from the start. Because dealing with administrative agencies, there are a lot of technical rules that have to be followed, and it's easy to violate those rules or not preserve evidence, and then then the court can't help you. So I can't overemphasize that enough.
Roger, we can have a much more longer conversation on this. So if people want more information, want to read in more of any of these details, they can go to your blog to find out.
Yeah, and I just posted this one yesterday, washburnlaw.edu/WALTR. I need to send it over to Rich Llewellyn at K-State this morning. Now, I apologize. This one is over 4,000 words in length. I try not to do that, but I got going on this one. I thought, well, I'm not going to break it up. I have to tie it all together and keep it all in one spot. So it's there. Maybe if people are having trouble sleeping tonight, they can pull it up and read it.
All right. Roger, as always, appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.